We have a caller waiting now. So Vicki from Cahaba Heights is joining us. Vicki, we appreciate you staying up late tonight. We're here to help. How can we do so?
Hi.
Vicki.
Thanks for taking my call. My husband had multiple cerebral stroke about 16 years ago. He was 46, and it just came out of the blue, and so we were completely caught off guard. And his brain is injured so that he can't really make a lot of good decisions. But we're lucky in that he knows who we are, he knows who I am, he knows I'm his wife, and all of that. But I tried to get a power of attorney back then because I didn't have anything, and I was told that I couldn't because his brain was injured so that he couldn't make that kind of decision. But now, 16 years down the road, he's a little better, enough to where he can say, yes, I want my wife to speak for me, or, So should I try to get a power of attorney for him now? And what else should I get for him,
That's such a good question.
to protect me?
That's a great question.
Great.
Vicki.
Yes.
I didn't hear it.
What she is asking, in essence, James, is if someone is trying to get a power of attorney over someone who has mental incapacities, what does the law require in terms of the person with the mental incapacities? At what level is that person able to give consent for a power of attorney versus when they're not?
Okay. Well, the first rule on power of attorneys is that you need one generally early, because most people will be disabled at least for a few days sometime in their life. And a lot of people are disabled a lot longer than that. And if that's the case, somebody's going to be paying your bills. Now, the reason why you want to have the power of attorney is that if you've got a pulse and you're not judged by a court to be mentally incompetent and you're over the age of 19, you can sign a power of attorney. But if you say get in a serious car accident and you lose that capacity, then your family's going to have to get a conservatorship for you to handle your money. And there's nothing cheap about a conservatorship. It's a lot of work to do it.
Right.
And so you don't want the conservatorship. You want to have the financial power of attorney around at a pretty young age for you.
Vicki was asking about her husband and whether he had capacity to do a power of attorney. And she told us that he actually has improved some over a 16-year period from some strokes he had, and now is capable of saying, yes, I would like for my wife to handle my affairs. But tell Vicki what things the court looks at to determine capacity.
The court looks for capacity at whether or not the person making the decision or signing in a document understands what he's signing and the consequences of signing it. And in some cases, I mean, if somebody, that capacity, or they sometimes call it lucidity, can come in and out. So sometimes you will have documents prepared, and when somebody's having a good day, you'll go bring in a notary public and get signatures on it. There's nothing, I mean, but you want to make sure you have two, witnesses, et cetera, on things like that, because they can be contested in court. And particularly powers of attorney are contested in court as much as anything. Because in fact, more estates are somehow wasted with a bad power of attorney than estates wasted out in probate. Because somebody will get power of attorney and start spending somebody's money while they're still alive. So you'd have to be real careful about it, real careful.
Very serious.
Very
serious
yeah.
decision.
That's great advice, Vicki. We certainly wish you the very best with that situation moving forward.